Hi guys. If you're going through divorce and wondering about custody and what it all entails, you're in the right place. First of all, custody means that it's responsibility of a parent or parents to decide about where the child is going to live, which school is child going to go, and therefore there are two types of custody. Legal custody is about decision-making process, and physical custody is where the child is physically live and what the parenting time would be. So let's talk about legal custody. If legal custody is joint, that means that both parties would decide where the child is going to go to school, where the child is going to live, which religion the child is going to exercise, and which doctor to pick. And it's very important that both parties actually define joint legal custody. Why? Because the code section itself says if both parents have joint legal custody, they can make unilateral decisions for the child unless the court specified otherwise. So if you would like the other parent to not make unilateral decision about the child without your consent, then you would need to have an agreement that would specify what joint legal custody means, and typically it involves all the things I just mentioned, and clarifies in the agreement that none of these things, enrolling into school, medical, doctors, can be done without the other parent's consent, written consent, and email could be enough. So that's legal custody. Now, physical custody is where the child is going to live primarily, which address is going to be used to register to school, and what parenting schedule is going to determine how both parents are managing their time with the child. Now, the most common in a best case scenario, non-high conflict case, in a regular divorce of a small child would be 2-2-3 schedule. What it means is 2 days with mom, 2 days with dad, so Monday, Tuesday, and then with dad Wednesday, Thursday, and then the weekend with mom, and then reverse so that every parent gets every other weekend. And the child doesn't have long periods of time without the other parent, which could create a lot of separation anxiety for a small, very small child. As children grow older, some schedule that parents adopt that they like is week on, week off. It's more for high conflict cases where the interaction that they would like to have is minimal. The exchanges are at school. If school is not in session, a doorstep of the other parent where the receiving parent drives. So those type of schedule is also acceptable.
I created this book to help you understand the divorce process without getting lost or without getting a heart attack. You can buy it on Amazon in all formats, including audio format.
Common challenges in custody. Number one, some high conflict cases could involve alienation of the children, where one parent is intentionally or unintentionally, for example, intentionally when the parent is telling the children straightforward that the other parent is not good for all these reasons, and unintentionally would be when the parent is talking on the phone with someone else in the earshot where the children are, and they're on their iPad, but they can hear. So alienation is a huge topic. Or false accusations of any sorts. Sexual harassment, false accusations are getting since the code section passed, where a false accusation of sexual harassment could lead to sanctions and potentially reverse custody. It became less prominent. It's getting better. But false accusations of potential abuse, of things like that, are still involved. And in those type of cases, the court could say that custody evaluator would be appropriate. Who is custody evaluator? Custody evaluator is an independent professional usually psychologist, who is getting involved and writing a report with recommending schedule. And before arriving to a conclusion, it would be that the custody evaluator would speak to each parent separately, to the child separately, go to the parent one location home where they live, parent two school, speak to collaterals, usually school teachers, therapists, and friends and family. In super, super high conflict cases, the court could order minor's counsel. Minor's counsel is a lawyer for the child. Regardless of their age, the minor's counsel would make a suggestion to the court about what the minor's counsel thinks would be in the best interest of that child. And let's say if the child is over 14, of course, the minor's counsel would be able to speak to their client, and a 14-year-old's wishes would be considered for the purposes of visitation and custody. Second challenge in custody proceedings could be domestic violence restraining order. Relocation cases are really, really tough. And overall, custody proceedings, in order to start one, parent who is seeking to have a schedule would need to file a form called FL 300. It's called Request for Order, assuming you have already a case number. So if you don't have a case number, then you would need to file either for divorce, legal separation, parentage proceedings, custody proceedings, and then you would be able, once you serve on the other parent, not you, but anyone over 18, once they serve the first tranche of paperwork that initiated the case, then you would prepare FL 300 with explaining in your declaration what schedule you would like, and then file that with the court. In San Francisco, for example, you would also have to serve the other parent not only the request for order with a court date, but also instructions for the tentative ruling. Because in San Francisco and Marin, the court issues 1 day before the hearing date, between 2 to 4, a tentative ruling that becomes a ruling, so means no appearance is required next day if nobody objects. But again, in San Francisco, if you do file a custody proceeding case, and in most counties, you will get a mediation date. Mediation date is where the court is going to send you to a mediator to resolve custody-related schedule or custody-related issues. It typically is combined with orientation, which is a video about half an hour long, and then mediator, depending on the county, is going to make a recommendation that is binding. It's called recommending mediation. For example, Alameda County, Marin County is recommending county, which means the court usually adopts the recommendation of the mediator. In San Francisco, it's not a recommending county, so there will be nothing presented to the court other than whatever each party filed, and the court will make a determination. Typically, the court will set a hearing on a Monday calendar, which is the mediation and orientation calendar, where the court is not making any rulings. And then after mediation on Monday, the court will set a future date, which is either Tuesday or Thursday, and then day before the court will make a tentative ruling. And if not objected, as you know, it will be a ruling. Now, this is how you start the proceeding. This is how you end. If it becomes highly conflicted situation, the court will potentially set it for trial, especially if one party will ask for it. It's typically done in cases where domestic violence restraining order is involved, relocation cases, or other highly conflict like alienation, false accusation of sexual abuse, or any of those type of cases where it's not possible to resolve in 20 minutes, where expert testimony must be taken or witness testimony will be taken. So then the court will ask, how much time are you estimating this proceeding and how many witnesses are you going to have? And then the court will set it. I have to say, in over 13 years, every time we estimated some time, it went over. So if I were to set a hearing date, I would actually ask the court for the double time than what I think we need, because it's better to set it now than to set it in the middle of the trial when the court has no available calendar. In San Francisco, again, in order to have a better calendar, it would be better to shift the case to, if the case is longer than 4 days of trial, to shift it to Department 4 or 5. So you got to know your local system, because if you don't, and let's say you set for 2 days when it's actually going to be 4 days, then you're facing potentially spread out dates over 9 months versus getting on the calendar to 4 days, and then maybe if you're lucky, finish it in 3 days. You got to be very, very aware of the court system you're in. So I'm giving you an example in San Francisco because every court system has different type of setup. So you got to know. And it's better that you consult an attorney who practices in that particular county so that you know all the intricacies. I hope that was helpful. I will see you soon in my next video. Bye.